Hello, everybody. Hello, everybody. Welcome back to the show. We are live for yet another week, going through some SQE prep tips and SQE questions and all the rest of it. And I'm happy to see you guys. It started off a little bit weird, but it's gotten better. So it's a nice, relatively sunny day in London right now, and we are going to get together and kind of work on our prep, because you know what, guys, we are so close. We're getting close to launch date. So anybody here who is preparing for SQE1 in July, now we're only 2 weeks away, 3 weeks away. Yes, seems like this. So I know that you're probably kind of gearing up for the last elements of your prep, and you're all getting a bit stressed out. So this is normal. So yeah, let me just count. So we go 1 week, and then we've got, we're like 1, 2, 4, like 3 weeks away. 3 weeks away from kickoff for SQE1. So in case you guys are getting stressed out, just be mindful that you are not alone in this journey. There are a lot of people who are going through the same experience, and they're going through the same anxiety at the moment. So there are loads of candidates out there. The problem that we've got is that due to the nature of the exam and the nature of many of you can either preparing part-time or working independently, you don't get the chance to kind of hang around and compare notes and experiences. But trust me, there are a lot of people who are going through a very similar experience at the moment. We've got some people watching us live, so thank you very much, guys, for tuning in. Let us know in the chat whether you are preparing for SQE1 coming now in July, or whether you are preparing for a later installment of this examination, perhaps in January 26. Yes, so the people who are preparing for January, they've got a little bit more time. So it is a little bit more straightforward if you've got 6 months ahead than if you've got like a few weeks ahead. So I've been trying to get in touch with kind of various candidates and see how they're getting on, and see what is available for people and the sort of things that they need in their last moment prep. So I came across a Reddit group called SQE Prep or something on Reddit, which is actually a very nice group. It's weird how in different social media you've got different behaviors. On Facebook, that I've got like a big public SQE Prep group that's got about 4,500 people on it. There are loads of people there that see the messages that I put on, but there's very little interaction. It's very unlikely that you're going to get somebody who posts something about their experience. If I ask them something, then we do get a little bit of interaction and a bit of response, but people are a bit inhibited in contributing on their own. And for every real person that is in there that is trying to say something about their experience, there's about 50 or 100 bots and spammers and scammers. It is incredible what a cesspit Facebook has become. Even for groups that are specific for a purpose, like these SQE prep groups, they're inundated with people trying to sell you kind of scammy notes and scammy MCQs and all of that stuff. So a note of caution, especially if you are at the last end that you're preparing for SQE1 in July, and you're starting to get a little bit stressed, and you're thinking, oh, I need something more. Maybe I need some resource. Maybe I need some mock exams. Maybe I need some notes. Maybe I need some flashcards or post-it notes or whatever it is that somebody else has prepared. Do not fall for those scammers on Facebook. I do my best to kind of cut them out of my group. So I review all posts. So I don't let any messages through that on the main feed that are kind of spammers or scammers. On the chat, the occasional one manages to get through because my moderation, powers are not the same in the chat, but I'm doing my best to keep them out. On other groups, however, it is absolute mayhem. So if you go and look for SQE preparation groups on Facebook, and there are a few that have gotten quite big, like 90% of the interaction is spammers. So do not get sucked in. Do not send your money to somebody random. All these people are fake. There's nothing genuine about it. Anybody who kind of goes, oh, I found the books and I'll give them to you for a discount, they're probably selling really, really old copies or something that's been copied illegally. And remember that as future solicitors, you've got to fill in the ethics forms, right? And you've got ethics obligations. So it is really bad to start your SQE journey by trying to obtain kind of illegally copied notes or kind of hacked PDFs or books from the prep schools that you shouldn't be having. So keep that in mind. That would be a horrible thing to do, that you get caught in something like this and then it counts as an ethical violation that prevents you from joining the profession. Imagine. But I mean, people must fall for this, otherwise the scammers wouldn't do it. So this is what's happening at the Facebook end. Now on the Reddit end, I'm sure there must be a lot of scammers and spammers, but the Reddit groups seem to be a little bit better moderated. And I'm getting some genuine interaction in there. So, I'm fairly new to them. So I started posting on one that looked interesting. And, I get the responses from what appears to be real people. People are having an interesting discussion. They respond to the stuff that you ask them. And it all seems real, okay? So maybe Reddit is a little bit more real than Facebook, but you have to be careful out there. But we're talking about free communities here that are open to everybody. If you're into a controlled community, because I've also got a special Facebook group that is for the people who are paid members of my channel. So of course this one is vetted for the people that go in, and there's a smaller number of people. So clearly the interaction that you get in there is fairly different from the one that you have in the public groups. So if you are in a private group, great. If you are in a public group, just be careful about the level of interaction you're having. And if you're in a WhatsApp group, be super careful. Because I think I've seen a lot of people who are quite liberal in giving their phone numbers to join WhatsApp groups, and that really, really worries me. Because for the moment that somebody gets hold of your phone number and your WhatsApp number, and then can kind of pass this on to all sorts of things, and you're going to start receiving kind of weird calls and messages and stuff. And, the better spammers and scammers are actually quite realistic in what they do, and they can get you in trouble. All right. So how are we doing otherwise, guys? Did you enjoy the sunshine? If you're in London, it's been incredibly warm and sunny the last few days, which is unusual. So we kind of forgot what we were complaining about all this previous time. But I do sort of remember, because we used to have live streams at the beginning of the year as well. I remember logging on every week, and every week was like dark, leaden skies, right? And kind of cold and miserable, like days on end. So at least we can enjoy the sunshine now, and today has gotten a lot better. Okie dokie. Say hi in the chat. Don't be afraid. I see that we've got people coming in and out. I think some of you get kicked out when YouTube starts playing ads on you, and then you come back in. So say hi in the chat. So I know who's here, and we can get going on the show. So let me take a moment to try and share my screen. Now, normally I manage to do this effectively. Now, it should all be here. Let's see what happens if we press the button. Whoop, no, not wrong button, not that button, this button. Let's see, window, okay. So hopefully now the screen should change, and I'm going to revert to being a small man in the corner while you're seeing the slides in the bigger screen in front of you. So let's see, did we manage this, or are we still getting a black screen? Yep, we have managed. Hooray! Okay, so welcome to another episode of Live SQE Prep with me, Dr. Yanis. Now, first of all, first things first. Anybody who is looking for last-minute prep support, there are quite a few online tools that generate multiple choice questions, mock exams, and all the rest of it. So the latest one that I got my hands on is called Kinu. These guys are producing multiple choice questions with the help of AI. They've got a team of people that kind of curate and review those questions to make sure that they're appropriate. So I've gone through a sample of them, and they all seem to be good, difficult questions as they need to be for the SQE. They've also got an AI feedback function that tells you why the correct answer is correct and why the wrong answer is wrong and all the rest of it. And you got the ability to get additional information. So this is a new product that's come in the market, and they've given us a discount code. So if you guys want to try this, be mindful that this only works up until the end of the month. So this is like an initial kind of get us to know each other exercise. So if you use the code Ioannis50, spelled the way that you see it on the screen, you're going to get 7 days off like you normally do when you sign on to their product, but then you get 50% off for the first 3 months of your subscription. Of course, you know, there are terms and conditions as usual. It's only for new subscribers and all the rest of it. So if you guys want to give this a shot, then you can try this out and let me know what you think. And there are a variety of other tools as well that produce certain the similar things, additional discount codes, and information on my newsletter that goes out every Monday. So maybe some of you got the latest installment of the newsletter yesterday. Every week I send you guys fresh multiple choice question, and discount codes and tips on your revision and resources to look at, and the question from the previous week plus answers with all the details as to why the correct answers are correct and the wrong answers are wrong, to help you guys with your revision and kind of help you bed in your prep. Now, having said that, I am also trying something new because, you know, I am the man of endless ideas. So I relentlessly throw new stuff at you guys to see what happens. Do you guys listen to podcasts? Who do we have in here that listens to podcasts? If you are fans of podcasts, give me the thumbs up. I find that lately I watch less and less TV, or, you know, to be honest, I do the same thing that everybody else does. If I switch on the TV, I put on Netflix or, you know, something on Prime or other, but I hardly watch any broadcast TV. To be honest, I only put on the broadcast TV for the news, especially when there's kind of unpleasant stuff going on around the world, and we've had quite a lot of that happening lately. But I also found that lately I'm listening to a lot of podcasts. On a variety of topics. Primarily, I listen to stuff about AI and education, and I watch some kind of sort of funny side, comedy style politics shows. But I do find that I listen to a lot of podcasts, and I've had a lot of discussions with candidates and a lot of people who told me that there doesn't seem to be any decent student-focused or candidate-focused podcast. And certainly not one that is focusing on SQE candidates. And for that reason, I thought, hang on a second, I'm sitting on all this content here. Already on the channel, I've got quite a lot of material that is in the form of an audio, mainly like an audio lecture. So it would be an interesting idea to repackage this material in the form of a podcast. So what I've done, I've created the scripts in the form of a two-person discussion, and I'm going to release episodes where I'm going through the various topics of the FLK one by one. So instead of you guys listening to me deliver a lecture for, I don't know, like 20 minutes or half an hour or 40 minutes or whatever it is, explaining the topic, the same material is packaged as a discussion. Now, I think, I mean, you tell me what you think and let me know down in the comments to this video. But I've got the impression that this might make the content more digestible. It is perhaps easier to listen to, or not as boring, or, you know, it's a little bit more kind of spiced up, so it keeps you guys engaged if you're introduced to this material in the form of a discussion. Now, clearly, I don't have the capacity to record this stuff live in a studio. I would love to do this. So if these podcasts become successful and you guys are finding them valuable, then maybe I could at some point sit with people in studio and do recordings of having actual discussions about these issues. Currently, the podcasts are produced by AI voices. So I do the script and then I feed it to the text to voice, and then the AI voices offer the discussion together. But Let me know what you think about this. Some people don't mind. Some people really dislike the AI voices. I think the quality here is quite good in the sense that you forget how it's made and you focus on the content of what it's saying. And I think as we kind of discovered around YouTube, every successful video is one where people don't focus on the production value, but they actually focus on what is being said. So is the substance of what is being delivered valuable to people? This is what matters. So hopefully this is what you guys are going to get by watching those podcasts. So I'm going to put a link to the podcasts down in the description if you guys are watching this on the replay, but it's very easy to find. Apparently, nobody else has this name. So if you go and Google Functioning Law Podcast, then this is the only thing that's going to come up. And I've got 4 episodes already. 2 of them are public for everybody on formation of contract and on company formation. And I've got 2 more episodes. One's on taxation and the other one is on tort. I was doing it yesterday on nuisance and occupiers liability and the rule of Rylands and Fletcher and all of that stuff. The last 2 are available to my channel paid members at the moment, but they're going to become available to everybody in the next couple of weeks. Now, if you cannot wait, you can pay the $2.99 a month and become a paid supporter of the channel. So this earns you my eternal gratitude, and you also get to watch all the videos that are listed. And I've got videos already in the pipeline from here all the way till October. So you can watch all those videos straight away without having to wait. And you also get to participate in the special Facebook group that is for members only. And who knows? I mean, now that I'm getting acquainted with Reddit and I'm having a good time over there, maybe I'm going to move on to a Reddit group. Would you guys prefer Reddit to Facebook? Shall we put this in a little question? So let's see, Facebook or Reddit? Where would you guys hang out? It's possible that this is a generational thing. Anybody under the age of 30 would rather be on Reddit. Anybody above the age of 30 probably knows Facebook. I don't know. I am perhaps the demographic that should be on Facebook, but I try to get out of it and be on different things. Not Twitter, though. I've had enough of Musk and that nonsense. So I've migrated away from Twitter. So now you can find me on Blue Sky. Okay, are we ready for some questions? Yeah, this is the meat of the show. This is what you guys are coming here for. So after like a few minutes of waffling on, it's time to hit our actual questions. Okay, question 1. Sophie and Daniel are childhood friends. They want to start a business selling handmade sustainable clothing. Sophie has significant capital to invest, while Daniel has experience in fashion design and marketing. They are debating whether to form a partnership, a private limited company, or a sole proprietorship. They're concerned about potential liability for business debts, taxation, and how much control each of them will have over the entity's decision-making. Sophie wants to limit her financial exposure, while Daniel wants flexibility in running the business, but wants to avoid any excessive administrative burdens. Question for you. Which of the following business structures is most suitable for Sophie's and Daniel's needs and why? Is it number 1, a partnership, as it offers flexibility in decision-making and profit sharing, but both Sophie and Daniel would be personally liable for business debts? Is it 2, a private limited company, as it limits Sophie's and Daniel's personal liability, provides flexibility for investment, and allows a clear division of control? Is it 3, a sole proprietorship, as it is easy to set up and gives Daniel full control of the business, but Sophie can act as an informal investor? Is it 4, a partnership, as it allows Sophie to invest as a silent partner without any personal liability for business debts? Or is it 5, a private limited company, as it avoids any taxation on the company's profits, allowing Sophie and Daniel to keep all earnings personally? Okay. What do we think about this? Now, if you guys have been, following the channel and my various kind of business law lectures and podcasts and videos over there, because I've got quite a few, you probably guess what my suggestion is gonna be. My suggestion is what it always is. My suggestion is that the best way forward is to set up a private limited company, because that will limit the two people's, Sophie's and Daniel's, personal liability and provide flexibility for investment, as well as giving them clear guidelines of how they do stuff, how they share in the profits, and all the rest of it. So my recommended correct answer here would be number 2, a private limited company. Why are the rest unsuitable? The problem with the partnership is that a traditional partnership does not offer you a clean division between your private and the business finances, meaning that you don't benefit from limitation of liability in case something goes wrong with the business. So if you're partners in a business and the business runs out of money to pay its bills, the various creditors are going to come after you personally, and you don't have the capacity to say, sorry, that was business debt, this is my personal assets, I don't want you guys messing with my personal assets. Because the partnership in its traditional form, the one that existed in the legislation from like the 19th century, does not offer a limitation of liability. So if one of the objectives is protection in terms of liability, then partnership is not suitable. So number 1 and number 4 that talk about partnership would not work here, because they certainly don't satisfy Sophie's requirements. We do have what we call a limited liability partnership, which offers some limitation of liability that might satisfy some of their objectives, but that is not one of the available options here. So number 1 and number 4 definitely is not going to work. Now, number 3 totally doesn't work, because if you are a sole trader or a sole proprietor, first of all, you're by yourself. So by definition, this isn't suitable here, because we're not talking about a single person here. We're talking about two people that are trying to do something together. And secondly, being a sole trader has got no division of liability and no division of assets between the business and the personal. So if this is one of the key asks of Sophie to limit her financial exposure, then having, I don't know, Daniel run it for himself and her being a silent investor definitely doesn't do that. So 3 really is unsuitable. 5 is wrong. Okay? Because 5 says that a private limited company avoids any taxation on profits. This is just wrong. So if you go back to the way that we think about answering problem questions for the MCQ, we're always going to have this pattern. We're going to have a fairly lengthy scenario that goes on for a few lines, and then we're going to have 5 available options. And from these 5 available options, there are going to be a couple that are totally wrong or unsuitable, and then the rest are going to be broadly relevant. So your job becomes, from the relevant ones, to ferret out which one is closest to what the question is asking. So be careful with this. When you're answering MCQs for the SQE, you're not going to have one absolutely correct option amongst the 5, right? It's not like one is correct and the other 4 are totally random. What's going to happen most of the time is that one is going to be very close, so that's the best possible answer. You're going to have a couple that are relevant but not quite perfect, and then you're going to have 1 or 2 that are clearly wrong. Either they're talking about the wrong thing or they misrepresent what the law is, and that's why they should be discarded. I've got a video talking to you specifically about how MCQs are built, why they're built this way, and what are the best ways to kind of make your selections. So I'm going to publish this shortly, so you'll be able to see it. But the key logic is this. You've got a scenario, you've got 5 available options. Out of those 5, a couple are going to be clearly wrong, either on the facts or on the law. And out of the 3 remaining, they're going to be all kind of broadly relevant, but one is going to be closer to the price than the rest. So to apply this to the situation that we've got here, the one that is closest to the price is number 2, that talks about Sophie and Daniel selecting a private limited company. Yeah, does this make sense for you guys? If it does, and if it's working out, give me a thumbs up or put a note or like a kind of happy looking emoji in the chat, so I know that you guys are finding this useful. And hopefully this communicates, because this is what you need to do. Yes, I think I saw a flying emoji there. I mean, I don't know, guys. I don't know. We can debate whether this is an appropriate way to examine stuff, and we've talked about this before, and everybody knows that I've got reservations about the introduction of the SQE, and I've got reservations about how it's structured, and I did up until recently have grave concerns about choosing a multiple choice test as the best way to examine people's competence, especially if we're asking people to demonstrate the day one skills and competences for a solicitor, which is, the sort of stuff that you should be able to know and do on the first day that you're starting your job as a solicitor. So I was always concerned about this. But between my concern, because remember, we've been talking about the SQE and all of that stuff for like 4 or 5 years now. In the time that has passed since they told us about this, and we started preparing and adjusting, and we started kind of thinking about what it was, till now, we had what? What did we have? Quickly, put it in the chat. What has changed in the last few years that has kind of revolutionized the way that we do stuff? It was the AI, right? It was ChatGPT. Now, the problem is, any other type of assessment, not the oral assessment, and you guys are going to be showered with this when you go and prepare for SQE2. I'm not talking about the oral stuff, but any other type of non-invigilated remote assessment these days is written by ChatGPT. I know, you know, I know, right? Everybody knows. Anything that you have to write down and you're doing it without somebody watching over your back, you do it with ChatGPT. And to be honest, why shouldn't you? If you know how to use it and you got used to using it, it produces spectacular results, both in writing stuff for general usage and writing stuff for legal usage. And it can, to a great degree, do with confidence and with successful outcomes a great deal of background legal research. And it can draft a great deal of relevant legal documentation. And it can help you understand how best to serve your client. And it can do this in its kind of whole scale versions, but also there are a great deal of outfits that are selling these capabilities specifically for law firms, packaged in ways that, help people that have concerns about the privacy of their data and confidentiality and so on. But the reality of the matter is that the AI does have spectacular capabilities, and we should all get used to using it, and it's going to be to our advantage. But when it comes to assessment, when you're assessing somebody's competence, if that assessment is remote and non-invigilated, then you don't know what you're assessing, because you're probably marking ChatGPT as opposed to the candidate that you think you were supposed to be marking. So in a ridiculous way, the SRA has been ahead of the time by setting this up like the American bar exam that is multiple choice test based, because you cannot use ChatGPT to answer your multiple choice test, because you're doing it in invigilated conditions in some sort of dingy VU X hotel or kind of dungeon that Kaplan has paid for in order to house you guys. If we've got anybody who sat the SQE already and is going for a second attempt, you know exactly what I mean. The SRA has gotten Kaplan to run the exam. Kaplan is hiring VU, that's got the same people with the cinema, right? That's got the test centers. And what do we know about Kaplan and Wu? What are they best of? They're the best for being the lowest bidders. So they always go for the cheapest thing available. So you got horrible examination centers in horrible conditions and horrible computers to write it on, for which you're paying a ton load of money. You are. I know. Makes me want to pull my hair out. But at least, nobody's going to turn up and say, I don't think you genuinely deserved to pass this exam because I thought you had ChatGPT whispering in your ear. That's not going to happen, because unpleasant the environment may be and weird the multiple questions may be, but nobody doubts that you were there by yourself and what you got in your head when you were attempting this exam. And after that, you go out in the real world and you should be using all the AI tools to help you produce better product for your client. But till we get to that, you need to remember these things by yourself, which is why we're engaging in these exercises here, especially if you're getting close to your exam, if you're preparing for July, because practice. The more you practice the MCQs, you better you get at it. The more you are linked to this material, the more you're likely to remember. So you need to wash yourself, surround yourself, drown yourself with SQE related information, especially as you're getting closer to the exam, in the hope that things stick. And that's why I spend so much time producing the same content in a variety of ways. So you can read your books, you can read your notes, then you can read a flowchart and an infographic, and then you can read the summary, and then you can read some lecture notes, and then you can read some cards to remind yourself, and then you can listen to my lecture, and then you can listen to my discussion right in the podcast. And it's just the same stuff that is getting delivered to you in different ways all the time. And through familiarity, you will begin to remember. Yeah. So don't just rely, that's my advice, right? Don't just rely on the books that have been given to you by your prep provider. It's helpful that you approach the same content in different modes. So use the text, but then try something in audio, try something in video, try something in different visual presentations of that text. The more you're exposed, the more you will remember. And, if there are areas of the law that just you cannot remember or you don't understand in any way whatsoever, then let's try and talk about it, okay? So if there are areas of the law that present you with particular difficulty and you don't understand it, talk to other candidates. If you're in a prep school, talk to other people. If you have a tutor, talk to your tutor. If you're at uni, talk to your lecturer. If you cannot find anybody at all, talk to me through Reddit or Facebook. Yeah. So the important thing is not to be left with gaps and areas of darkness in your preparation. And for the stuff that you do understand, you just need to go over it again and again and again to remember, then use all these different modes we've got. And sooner or later, you will be in that dingy exam room, and you'll sit the exam and you'll come out of it and you'll pass, and then you can forget about the damn thing and just get on with your lives. Yes. There is life after the SQE. I know. Not for me, because since I took it upon myself to work on the SQE and to kind of help candidates, I'm probably going to be doing this forever, but there's life for you after the SQE. All right, let's see our second question. James, right? Well, who's James? James is a solicitor at a mid-sized law firm, and he's representing a long-standing client, Olivia, in a property dispute. Olivia tells James that she plans to dispose of certain key financial documents before the opposing party asks to see them. She believes that these documents might weaken her case. James is aware that the opposing party is likely to seek disclosure of these documents during proceedings. Olivia insists that the firm should proceed with the case as if the documents never existed. James now is facing a dilemma. So this is a problem between his professional obligations and his obligation to serve the client and their instructions. So he seeks your guidance on how to handle the situation. So under the SRA's code of conduct, what should James do in the response to Olivia's intention to destroy this evidence? Should he advise Olivia that destroying the documents would be unlawful and refuse to continue representing her if she insists on destroying them? Should he proceed with the case while remaining silent about Olivia's actions, as he owes a duty of confidentiality to his client? Should he inform the court immediately about Olivia's intention to destroy the evidence, as solicitors have an overriding duty to the court? Should he ignore the situation, as it is Olivia's personal decision and not his responsibility as her legal representative? Or finally, should he advise Olivia that if she wishes to destroy the documents, she should do so without involving him to protect solicitor-client privilege? Aha. Okay. Not a very good situation. So James definitely has to find a way through this. Now, what would we advise him to do? If this has ever happened to you, do not tell me in the chat. So the solution here would be, number one, James should advise Olivia that destroying the documents would be unlawful, and he should refuse to continue to represent her if she insists on doing so. Now, why? Because we have to look at the Solicitor Regulation Authority's Code of Conduct. This says that solicitors have a duty to uphold the rule of law and the proper administration of justice. Within this, we've got an obligation that solicitors act with integrity. This is in Principle 5. And they are obligated not to mislead the court or others. Therefore, if a client insists on destroying evidence, that might be that and the evidence is relevant to proceedings, the solicitor must tell them that they shouldn't do it and that it would be unlawful. It could constitute contempt of court or obstruction of justice. If a client persists in their intention to act dishonestly, the solicitor must cease acting in accordance with their ethical obligations. So this is a little bit different from what happens in other jurisdictions, right? But here, if you know that the client is doing something inappropriate, then you have to inform them that you can no longer represent them, because you do not want to find yourself involved in something that you know is unlawful, and you have communicated this information to the client, because your primary duty is not to the client. Your primary duty is to the court. But let's investigate why the rest of the options are not as good as this one. Option 2, it said proceed with the case while remaining silent. This is incorrect. Remaining silent would breach the solicitor's duty to act with integrity and may constitute professional misconduct. Okay? So you cannot just zip it and go and let her do what she wants to do. Now, informing the court, which is in number 3, do you have to do this? No. We said you do owe a duty to the court, but you're still not allowed to disclose confidential client information without the client's consent, especially in circumstances such as this one, unless, of course, this is about the prevention of the commission of a crime that is imminent. Now, I don't think that you could argue this in saying that here destroying the evidence could be a crime and you have to tell the court to prevent the commission of the crime. They're talking about things that have got danger to others that might allow you to breach your confidentiality provisions. So this isn't quite correct. You don't have an obligation to inform the court in violation of solicitor-client privilege in these circumstances. How about 4? 4 said ignore it, whatever. No, you cannot do this because we already said you've got your own ethical obligations and you cannot just sit aside and let the client do something that you told them you disapprove of. And 5, that if she wishes to destroy, she just shouldn't tell you, is incorrect for the same reasons. So what we've got here, 4 and 5 are clearly incorrect. Number 2 is also incorrect on the law. 3 is mostly incorrect. So the only one that comes close as the best possible answer is number 1. Okay. So thank you. I've got a comment in the chat that says Hamza is a fan of the long podcasts. Yes, I've got loads of those. So the playlist that is called The Whole Law, this is the one that contains all these long podcasts. So they are like complete breakdowns, complete lectures of various topics of the FLK. There isn't one for every topic of the FLK, but there's quite a lot of them there. But what I tried to do was to cover the totality of the FLK, both FLK1 and FLK2, in some form or another. So some of them are covered by the long lectures, some of them are covered by shorter summaries, and there's a sort of mix between those topics, because I'm also trying to see what appeals to people more. So if people are super happy with the hour-long lectures, I can do more of those. But if people don't really like those and they would like something shorter, I want to give people the option. The one thing that I'm investing at the moment are the discussion-style podcasts. I intend to make one of these podcasts for every topic in FLK1 and FLK2. So you guys can sit back and let this play in the background and cover the totality of the FLK through these sort of easier to digest, more pleasant discussions. So yes, I'm doing more. So Hamza, if you're talking about doing more of this format of the podcast with the 2 hosts, that's what I'm doing at the moment. So I'm just gonna roll this out across all of it. It's just that, some stuff I know super well, like company law, business law, contract, I know inside and out, right? So I've got no problem writing the scripts for those ones. But there are some areas that I'm a little bit kind of more careful because I don't know them that well, and these take me a little bit longer to produce. So the one that I put up yesterday that's available for channel members at the moment was on occupiers liability and nuisance and Rylance and Fletcher and all of that stuff. I was teaching this year, right? So I'm a bit fresh on my lecture notes, but still, it's not as funny for me as doing contract law and company law that I've been teaching for decades. But, also it's funny because trying to do this also helps me bring up my capacity on the other subjects, and I get to revise some stuff that I haven't touched since I was at law school, right? Especially the criminal law stuff, because criminal law I don't really do much. All right, cool. So correct answer here, ladies and gentlemen, is number 1. You should tell Olivia that she shouldn't do it, and if she insists on doing it, just tell her she has to find somebody else to represent her. Okay, let's see our next question. Okay. All right, now we are at question 3 with Daniel. Daniel is the owner of a luxury car rental business. He's entered into a contract with Speedy Repairs Limited to service and maintain his fleet of high-end valuable vehicles. Under this contract, Speedy Repairs is required to complete all maintenance work within 5 business days. However, because of staff shortages, Speedy Repairs took 3 weeks to complete the work. This caused Daniel to lose several lucrative rental contracts with corporate clients. Daniel estimates his lost profit at £50,000. He claims this amount from Speedy Repairs as damages for breach of contract. Speedy argues that they were unaware of the specific contracts Daniel had with his clients, and that they should only be liable for direct losses, such as the cost of hiring alternative repair services. Daniel insists that he communicated the urgency of the repairs during his initial contract negotiations. Which of the following principles will the court consider when assessing Daniel's claim for damages under the English law of contract? Is it 1. Remoteness of damage? The court will assess whether Daniel's losses were a foreseeable consequence of the breach and within the reasonable contemplation of the parties at the time of contracting. Is it 2. Mitigation of loss? The court will only award damages if Daniel took reasonable steps to minimize his losses by seeking alternative repair services. Is it 3. Liquidated damages? The court will award Daniel the full $50,000 as financial loss was clearly anticipated and quantifiable in the contract. Is it 4. Specific performance? The court will order speedy repairs to complete future repairs within the agreed timeline to avoid further losses. Or is it 5. Causation? The court will consider whether Daniel's losses were directly caused by speedy repairs delay without any intervening factors. Okay. Now, this is an interesting one, and I like causation and remoteness is one of my favorite subjects. And I recently put up a video, I don't know if you guys have seen it, where it's a bit of a kind of cartoonish animation discussing causation and remoteness in the context of you booking a cab to take you to the airport and the cab not turning up and you being late and missing your flight and then missing a meeting and then losing your job because you missed the meeting and then your wife divorcing you because you lost the job and everything, your whole life goes into the gutter because the cab did not arrive. And the question is, would you be able to sue the taxi company for all these losses flowing from the breach? And as you're going through the video, I take the opportunity to discuss how causation works, how the doctrine of remoteness works, and how you can sort of bring within a claim the variety of losses and which ones might be considered to be too far to be compensable and all the rest of it. So it's a video that I like. I thought it was fun. So you have a look at it and you let me know what you think. Now, what's happening here with Daniel? Let's look at what the question is actually asking, because the problem here is that you're going to go through the various 5 options and you're going to think, yeah, I mean, I don't know, man. I mean, most of them seem to make sense. So most of them seem to be related, apart from like perhaps we've got like a couple that don't seem to factually match, but the rest of them seem legit. So how are we going to make a choice? If the various options all look fairly legit, read again the exact question. Maybe you're missing something. So the question says, which of the following principles will the court consider when assessing Daniel's claim for damages under English contract law? Does that help us? Well, actually, not much, to be honest, because it's going to have to consider remoteness and mitigation and causation. So we can immediately discard 3 and 4. Which of the following principles will the court consider, right? Liquidated damages is irrelevant because it's not in the factual base here. If you can have a claim for liquidated damages, this means that you had a pre-agreed amount in the contract in case the contract is breached. So long as this is a genuine pre-estimate of loss, then you can bring a claim for liquidated damages, which is like a quicker pathway in proving your damages because you're pointing back to the contract and the court is going to be fine with it. If, on the other hand, you had included an extortionate amount as a pre-estimate of loss that is not a genuine pre-estimate, then the court is going to consider this a penalty clause. And remember, penalty clauses are not allowed in English law, right? So you cannot penalize the other party for having breached the contract. You can only ask to be compensated for the losses that you have actually suffered. But in any event, we don't have a pre-estimate of loss built into the contract at the time of contracting. Daniel estimates his losses subsequently post-breach. So 3 is not within the factual base, therefore it's wrong. Specific performance is also wrong, both for technical and kind of factual reasons. They're arguing about what has happened already. The question is not to kind of discipline speedy repairs to do their job properly in the future. The whole thing is about what has happened already. That's what their dispute is about. So 3 and 4 are clearly out of the scope of what the question is talking about, so they are wrong. So we're left with causation, mitigation, and remoteness. This is a problem because all of them are potentially correct answers. Which of the following principles will the court consider? Yeah. So yes, the court will always consider causation. Is the claimed loss causally related to the breach? They will always consider remoteness. How far is this loss from the breach? And they will also consider mitigation. So did the parties take steps to contain those losses, or did they actually voluntarily make them worse? And if they have voluntarily made them worse, then you cannot ask, you contribute to the problem. So you cannot ask for compensation for the stuff that you yourself made worse. So how do we choose, right? What seems to be the argument here in the scenario is not about causation. They're not saying it's unrelated. It's not about the costs of alternative service. Yeah? What the problem in the scenario is about is Speedy Repairs saying, we didn't know about your follow-on contracts. So even though the question, which of the following principles will the court consider, doesn't 100% give us the answer, because both 1 and 2 and 5 are talking about questions to principles to consider, the gist of the scenario itself is pointing to remoteness. Because Speedy Repairs is saying, okay, direct consequences of the breach, awesome. We may be responsible for those, but look, we didn't know about specific super valuable contracts because you didn't tell us. So what they're trying to do is to say that under the Hadley and Baxendale test, one is responsible for losses directly arising from the breach. But anything that is not directly arising from the breach is only compensable if it is within the contemplation of the parties at the time of contracting. And Speedy Repair's arguments is that the expensive, valuable contracts with fancy clients were not in the contemplation, and they're not directly arising. Now, this is a dynamic area of the law because we've got cases all the time that kind of try to help us interpret how do we distinguish between direct losses and consequential losses. And if you're working in this domain, if you're working in contract drafting, or if you have been part of negotiations and you're talking about limitation of liability or risk, the distinction between direct and consequential is something that comes up very often. And every time in a contractual negotiation, you're thinking about limitation of liability, putting this break between things that will arise naturally in any event and things that, are a little bit off the track will be a significant barrier in helping you manage your risk. So this is important. Even though 1 and 2 and 5 could be potentially correct, we select again as the best possible answer, in this case, number 1. Yeah. So hopefully this explains the logic, and it brings us back to the discussion that we were having a little bit earlier about what is the logic of MCQs for SQE1, right? You give the scenario, you give the 5 options, a couple are random, but then from the rest, they all could potentially work, but you need to pick the one that fits the best. Yeah. Terrific. If you like that stuff and you're finding it valuable, hit the like button, and even tell your friends about the channel and the live stream, so we got more people turning up and we can have a chat. And even better, if you guys are finding this super helpful and it kind of blew your mind and you just cannot believe how awesome this is, you can click the thing in the chat that's got like a dollar sign that looks like a dollar note, and you could even send me money. Imagine this. So you can remote buy me a coffee by hitting that thing that with the dollar sign. You don't have to, but if you do, I'll make sure I go and grab a coffee in your honor. Okay, moving on. What do we have next? What is it? So we dealt with Daniel. Now we're moving on to Ecotech. Okay. Ecotech. Ecotech Limited is a UK-based company specializing in sustainable energy solutions. In the last financial year, they had a taxable profit of £500,000. Ecotech has some business expenses, including salaries, rentals for office spaces, research costs. They have already been deducted before arriving at the taxable profit figure. Additionally, the company has invested in new energy-efficient machinery that qualifies for capital allowances. The finance director is trying to determine the amount of corporation tax the company must pay and to figure out whether any deductions or reliefs are available. Which of the following statements correctly describes how Ecotech's corporation tax liability will be determined under UK tax law rules? 1. Ecotech will pay corporation tax at the main rate on its taxable profits, but may reduce its liability by claiming capital allowances on qualifying assets. Number 2. Ecotech is only required to pay corporation tax on its distributed profits, dividends paid to shareholders, rather than on total taxable profits. Ecotech can avoid paying corporation tax by reinvesting all of its profits back into the business instead of distributing to shareholders. 4. Ecotech's corporation tax rate depends on the personal tax rates of its directors and shareholders, as corporate profits are taxed as individual income. 5. Ecotech is only liable for corporation tax if it has overseas income, as UK companies are not taxed on domestic profits. Aha! Okay. Now, this is a more difficult area of the law because candidates tend to be less familiar with the tax issues. One of the podcasts that I just launched is on business taxation. So be sure to listen to that one when you get access to it, because it kind of helps with some of the fundamental concepts that we have to deal with in understanding how tax works for corporations. But overall, the student population tends to be a little bit scared of the tax stuff. And if you were recently at law school we don't teach about the tax. We hardly ever touch upon the tax implications of the stuff that we talk about. That's why this question looks complex, but it's actually easier than the previous ones. Why? Because it contains a lot of wrong answers. Yeah? Now, let's take them from the bottom upwards, right? Number 5 says, companies are liable for corporation tax if they have overseas incomes. UK companies are not taxed on domestic profits. That's wrong. Right? It's clearly and spectacularly wrong. So we can discard number 5. 4 said that corporation tax rate depends on the personal tax rates. No, it doesn't. Corporate profits, they're not taxed as individual income. The money that you extract out of the corporation and pay yourself, either as salary or as dividend income, that will be taxed as individual income. But the corporate tax itself is completely separate from any individual's tax arrangements, whether we're talking about the directors or we're talking about the shareholders. So 4 is also spectacularly wrong. Now 3, can companies avoid paying corporation tax by reinvesting all of their profits? No. Because once something is classed as a profit, then it gets taxed. What the company does with that profit subsequently doesn't really matter, okay? So if you have expenses, then you're not talking about profits, because expenses are deducted from the turnover that you had. So if something has been an expense, it will not feature in something that is called a profit. So I think it's trying to confuse you between the idea of sort of the overall business turnover and which part of it counts as profit, which part of it counts as expense. If something has counted as profit, then it's get taxed. If the money is retained by the corporation and not paid back as dividends or whatever, then they can reinvest it, but they've already paid tax on it. So 3 is wrong. Number 2 is also wrong because it says Ecotech is only required to pay corporation tax on distributed profits. No, whether you paid out the money as dividends and so on is irrelevant, right? So as I said, if something counts as a profit, then the company gets taxed on it and they have to pay corporation tax. If they choose to then give it as dividends, this is something that's been taxed already. So it's not that you only tax the dividends. It's not that you don't tax the dividends. This is like irrelevant to your what you do in terms of dividends is irrelevant to your tax liability. So spectacularly, this is what I said. This is an easy question because all the potential answers bar one are all wrong. Okay, so you don't have to agonize over, oh, this one could be correct, but does it really match or does it not match? And to go through the process we normally go through. Here, from 2 to 5, they're all wrong. The one survivor is the first one. Ecotech will pay corporation tax on its taxable profits, but may reduce the liability by claiming capital allowances on qualifying assets. Yeah, this is the only one that is technically correct. Are you guys afraid of tax? Give me like a scared emoji on the chat or something if tax is freaking you out. It's scary. And also, I'm guessing if you're into law, it's because you are terrible at math. Yeah. Usually the people that we get at law school, they're the people who are absolutely horrific in math and sciences and all the rest. And this was one of the primary attractions of doing a law degree, that and the fact that their parents told them to do a law degree. Yeah. So there you go. So perhaps it's kind of being afraid of numbers, being afraid of math, afraid of calculations, and the fact that nobody ever teaches anything meaningful about tax results in people being scared of the tax parts that you need to know for SQE. But having said that, it is part of the FLK. So you need to know the fundamentals of business taxation. You need to know some stuff about personal taxation. And then you need to know all this nasty stuff about inheritance tax and all the rest of it. And some elements about property taxation as it regards to conveyancing and all of that. So there is a bit of tax that you need to know. Right. Moving on to our final question. So what's our final question? Emma is looking to purchase a second-hand oven for her bakery. She visits a catering equipment supplier, BakeTech, where the salesperson tells her that the oven that he is trying to sell is in perfect working condition and has only been slightly used. Based on these assurances, Emma purchases the oven for £8,000. She installs it, but then she discovers that it frequently overheats and shuts itself down. She hires a technician to come and have a look at it. The technician informs her that the oven is 5 years old and has been previously used in an industrial kitchen and has got significant pre-existing mechanical faults. Emma's very annoyed by this and wants to take legal action against BakeTech. Question: under English law, which of the following best describes the legal nature of the salesperson's statements and what remedy is available to Emma? All right. Is it 1, fraudulent misrepresentation? Emma can claim damages and rescind the contract because BakeTech knowingly made false statements to induce her into the purchase. Is it 2, negligent misrepresentation? Emma can claim damages under the Misrepresentation Act of 1967 if BakeTech failed to take reasonable care in verifying the oven's history before making the statement. Is it 3, innocent misrepresentation? Emma can rescind the contract but cannot claim damages as the salesperson believed the statement was true. Is it 4, breach of contract? Emma can only sue for breach of contract because the salesperson's statements were part of the contractual terms. Or is it 5, she's got no legal remedy? The statements were a mere sales puff and do not form the basis of a misrepresentation claim. Aha. Okie dokie. Now, this probably guides you in the direction of misrepresentation because 3 of the potential answers here talk about misrepresentation, right? So there seems to be emphasis in the question itself towards misrepresentation. So I would not be surprised if the correct answer is one of the misrepresentation options. But let's deal with the rest first of all. Number 5, is it mere sales puff? No. This is really not very likely because it's not supported by the facts. Things have gone wrong here. The main question is, have they gone wrong in the misrepresentation sense or the breach of contract sense? Which brings us to potential answer number 4. How can you distinguish between misrepresentation and breach of contract? This is a very common problem for people. The important thing is to think about the requirements. Breach of contract requires that promises that have been made during the contractual formation are not respected. So you were promised certain outcomes that have not come about. The distance between what you were promised and where you ended up is what constitutes the breach of contract, and calculating that distance allows you to claim for damages. Misrepresentation, on the other hand, has got different requirements. Misrepresentation requires on a false statement of fact that induces you to enter into the contract. Okay? We need to have a statement. We need to have a statement that is false. We need to have a statement that induces you to enter into the contract. A false statement of fact is not a promise. And this is what distinguishes a misrepresentation claim for a breach of contract claim. It's possible that the false statement is also represented in the terms and conditions of the contract. So you might have the option of choosing whether you go for a breach of contract claim or a misrepresentation claim. Why would the choice be meaningful? You might have differences in remedies. The main remedy for misrepresentation is rescission. So the key way to respond to a misrepresentation problem is to say, oops, I want out of the contract. And if you have suffered damages on top, then you get out of the contract, which is the primary remedy, and then you can ask for the damages on top. The primary remedy for breach of contract is damages. So in certain circumstances, you can also terminate the contract and get out, but the number one thing you get is money. So if you are in a situation that you can choose either misrepresentation or breach of contract, think about what is the primary objective of the client. If the primary objective is getting out, then misrepresentation might be a more suitable avenue. If the primary objective is money, then breach of contract might be the more suitable avenue. But so this is like the sort of key, because they look familiar, and I understand why people are getting confused, but this is the sort of key distinction between misrepresentation and breach of contract. Different concept, different requirements to achieve it, and then different sets of remedies as a result. So if we discarded 5 as being very unlikely, and we discarded 4 because being in a perfect working condition is attractive but is not specific enough to constitute a breach of, to constitute a contractual promise, okay? Because contractual promises need to be kind of directly actionable stuff that people understand. If we fall back to the misrepresentation route, do we have a false statement of existing fact that entices the other person to enter into a contract? The statement was, it's in perfect working condition and has only been lightly used. So we have a statement for sure. Is the statement false? Yes, it is false. The technician has confirmed that the oven is in fact old and has previously been used and suffers from damage. Okay, so we have a statement. We have a statement that's false. Is the statement why do we say we need the statement of existing fact? Because we're trying to distinguish between statements and promises that might take us in a breach of contract direction. So here I'm confident that we've got a statement of existing fact. Did the statement cause Emma to buy the oven? Yes. This was the key information that motivated Emma to purchase that oven. There could be other objectives. It could be that the price was very attractive or whatever, but we don't need the statement to be the only reason. We need the statement to be the primary reason why the person enters into the contract. And we seem to have this, which is terrific, which kind of helps us validate our initial impression that 4 and 5 are not suitable as answers, and we need to choose between one of the different types of misrepresentation. Here we might have a bit of a problem. Fraudulent misrepresentation suggests that they're doing it with intent. So we need to be confident that the salesperson knew that they were lying. Innocent misrepresentation means that we need to be confident that they were not lying, that they had been supplied with the wrong information. Now, neither of those seem very likely, because we don't have anything in the factual scenario to suggest that, in fact, this person is lying and is doing it on purpose. Well, it doesn't tell us why they gave that information. It's also very unlikely to be innocent, because it's very unlikely that they've got documentation that suggests that this thing was perfectly fine when, in fact, it's come from an industrial oven and it already has damage. Yeah. So the more likely solution here is one of negligent misrepresentation, meaning that they were just talking and they didn't care, right? They didn't bother to verify. They just said what they needed to say to make it attractive to achieve the sale. They weren't sure they were lying, but they weren't sure whether what they were saying was right either. So it just went with it. So for this factual scenario, even though fraudulent and innocent might be possible, the more likely one, because we need to pick the best possible answer, the most likely one is the one that says negligent misrepresentation. There used to be the case that there was a significant distinction in the damages aspect of it. Most types of misrepresentation are going to give you the opportunity for rescission, which is to walk away. But then there was a debate as to damages, because in the past you could get damages only for fraudulent, but you could not get it for negligent. All of this has been solved with the Misrepresentation Act of 1967. So as question 2 says, it's possible to exit the contract because of the misrepresentation and then claim damages for any additional losses. So 4 and 5 are very far. 1 and 3 are going to be difficult to prove. Therefore, the best possible answer here is 2, that talks about negligent misrepresentation. Okay, so hopefully, I perhaps find this stuff easier because I spend so much time dealing with contract law and I kind of understand it a little bit better. But if you guys have got issues with this and are finding it tricky, I've got quite a few videos in a variety of formats about misrepresentation and what's going on. So guys, thank you so much for coming today. Thank you for your comments in the chat box. If you're watching this on the replay, feel free to put comments under the description of the video so we can continue to have our discussions together. If you're preparing for SQE1 in July, hang in there. I believe in you. You're gonna be fine, and we will be here to get through this together. This is session number 5 from this series of live streams. I've got another 2 to go before we hit the SQE dates. So I'll see you guys again next week. Till then, keep revising.